Very good morning to all of you. Welcome to the Medical Legal Conclave of Akriti. Akriti is a group of 18 friends who wants to do something different, not only sitting in a kitty and eating and chatting. In that way, the Akriti has come in front of you with the breast saga 6 months back, and today here we are with the Medical Legal Conclave, which is today is the burning topic for all of us. We are wearing a sari which is not white. Why? Because the white color of a doctor is become red with the blood of red and become little bit dirty with the why? Who is at fault? Whether we or the society? I think somewhere us, because we don't go to the society and tell our part. Because of that, today's the Medical Legal Conclave is bridging the gap with the society, with the lawmaker, with the policy makers. And my request to each of you, very much in time, very crisp message to everyone. And the extra talking is a main culprit. What you talk unnecessary in front of the patient, what your staff talk, and this sometime take you to the court. So learn here first thing to give the crisp message, precise message, follow the protocols, follow the SOP and document everything.
Thank you, Akriti, for this opportunity. I'm glad to be in the midst of so many, I would say I'm a deeply spiritual person, so many sisters and 3-4 brothers. So, I'm fortunate to be in that position that, when I'm a practicing lawyer, I'm not an advocate, I'm not registered with the Bar Council, but yes, all my clients are doctors who are into, fortunately or unfortunately in soups of medical negligence. So I have the opportunity to prepare their draft for either a consumer court, sometimes police inquiries, often daily medical council inquiries, of course. So what I prepare, the medical council decides what to do many times, So, medical law has changed since 2019. There is a huge change. Yes, we could say earlier to 4 years before 2019 that we don't know anything about medical law. Fair enough. But since 19, we cannot say our students know MBBS much more law, medical law than we do. Because now 180 hours of medical law and medical ethics have been introduced into the MBBS curriculum. So this is a new thing that we have to catch up. Our students would be much smarter than us and probably much more confident in dealing with these issues. और उसमें focus कहाँ है? The focus is more on communication skills. I've been teaching MBBS students from now medical law starts from first day of MBBS and continues to last day of MBBS. Okay, और उसकी application इतनी ज़्यादा है कि first year itself से now first month of MBBS is not formal medical education. It is the foundation course. And it's got nothing to do with formal anatomy, physiology, biochemistry or whatever. So there's a lot of change and we have to catch up with them. And अगर मैं communication skills की बात करूं तो उनको ऐसी 2 exercises सिखाई जाती हैं MBBS students को which runs in about 2 to 3 months. So they're very serious about all this because of what we are suffering as a generation. So my topic ideally should have been taken by probably an honorable justice or a practicing advocate, but I have an advocate who is sitting next to me, Dr. Neeraj from Lucknow, and he has all his clients also as doctors. So my perspective here would be to share that अगर आपके against FIR हो जाता है तो आपको weaknesses क्या देखनी है उस FIR में to benefit yourself, your case. एंड अगर आपको एफआईआर करना है किसी का कोई वॉयलेंस का इंसिडेंट हो जाता है तो आप क्या कर सकते हैं, क्या करना चाहिए, दैट इज माय पर्सपेक्टिव हियर. सो बिफोर before I talk about what is FIR and how to go about it, you need to know one very small thing: what is a cognizable and what is a non-cognizable offense. We teach it to MBBS students also. So this has to become like, we've been telling this for past 15 years, I am sorry to say, but our sister, Dr. Archana Sharma, would have been alive today with all humility and with all respect to the departed soul. Had we known about the Samira Kohli, about the Jagga Matthews judgment, we've been recommending it for the past 15 years. Don't leave your home without a copy of this judgment in your purse, please. It is so important. It can save your life, and as Justice rightly shared with you, it gives you privileges that not even members of Legislative Assembly, MLAs, do not have. So it is such a strong law that we have. And you cannot do without knowing each and every word of this. This Samira Kohli judgment, so many laws that we talked about. Yes, 10 years ago we used to say 20 judgments पढ़ लो Supreme Court की, National Commission की, you would know a lot about medical law. But now we are flooded with, our inboxes are full of what new judgments coming up from National Commission or Supreme Court, telling us more about, see, it is a dynamic science just like medicine, and law is also evidence based just like medicine. So we have a lot to catch up. So what is a cognizable and non-cognizable offense? A cognizable offense where a police officer can arrest a person without a warrant. Okay. So, and these are usually heinous crimes, and they need to be solved immediately. Therefore, they need not a warrant and can arrest a person immediately to solve a case of rape or a murder or a robbery, things like that. And legally speaking, it is defined in Section 2C of the Criminal Procedure Code. A non-cognizable offense, or NCR as it is shortly called as, so with due respect to the judicial officer, this is very, very basic, okay? Because FIR is otherwise a very huge topic. So I'm talking about very, very basic things that are, pertinent for our purpose as a medical doctor. Where a police officer requires a warrant in order to arrest a person, usually non-heinous crimes, कोई document खो गया, कोई छोटा मोटा incident हो गया, where a FIR, first information, need not be recorded in a police station, and a simple NCR, there is, every police station has a small book called as NCR book. इस size की होती है वो, उसमें top पे लिखा होता है non-cognizable report, okay, and it's got leaflets. So उसमें entry हो जाती है, although now all this is being done online now. And you can register FIR also online. In Delhi, it started in January 2022, last year, yes. And MP was the first state. Now FIR can be done in Uttarakhand, started last month. So the facility of eFIR has started also now. So legally speaking, non-cognizable offense is mentioned under Section 2L of the Criminal Procedure Code. But then what is an FIR? A FIR as such has not been defined under any law in our country. But then the FIR, or the first information report, mind you, some very basic principle. A FIR is only a report of the information given to the police. So it is not much. It can change with due course of time. I'll just explain in a moment. But it is only the information. And that is why the insistence by honorable courts of law that the police has no choice but to register FIR immediately, because it is only a document which mentions that a cognizable offense has been committed, period. It does not mean who is guilty or not. It does not mean whether the complaint is false or not. It is only about documentation of a cognizable offense. So FIR is registered only in case of a cognizable offense under Section 154 of the Criminal Procedure Code, as it is described as per police regulations and other things. So, and it comes, although FIR is spoken of from Section 154 to 176 of the CRPC. So in 2 lines, it is information to the police to commence a investigation by the police. And the information that is given to the police could be in 2 forms, whether oral or written. When it is written, it is all right, छप गया, अब तो सब कुछ type होता है, fair enough. But when it is given orally to the police, the law, it's 154 CRPC says that it has to be reduced in the form of writing by the police officer, and the police officer will have to read it out to the complainant who is giving the information of that cognizable offense, and the complainant has to sign it. So it is only an information to set the process of criminal justice system in motion. Okay, whether the person needs an arrest, that is the law will decide, the IO will decide as per prevailing law in that particular case. But it is just a piece of information about starting the process of investigation into a cognizable offense. Now, what is a cognizable offense and what is not is described for each offense in the Criminal Procedure Code. So the IO does not decide whether it is cognizable or not. The law is very clear. And since morning, since I've been watching, people sharing us, I have a feeling, see over here, we do not talk about feelings or experiences or observations. We talk about law, period. Like, we are in an era of evidence-based medicine. So everything that you write on a prescription paper is supported by some evidence, right? Am I right or not? Similarly, every statement in law that we make or write or we speak, it has to be backed by law. And as my previous, colleague was talking about, while preparing the reply, every statement that you write in the form of a reply has to be either supported by something that is already documented in your papers or is supported by some reference by textbook or whatever. Everything has to be supported. Otherwise, it becomes a weak document and you're going to lose in future. So, nowhere does it mean or has been mentioned in law that FIR is it means it is a Gita truth or gospel truth, that whatever is written in the FIR, वो 100% उसके अलावा और कुछ नहीं हो सकता. So as I said, the golden rule क्या है? Practicing advocates or even judicial officers will tell you 2-3 important things. First, whenever you are going to lodge an FIR, to make a strong FIR and to make your case strong, focus only on 2-3 important things: time of incident, date of incident, and the incident itself. कोई कहानी नहीं बनानी है कि मैं ऐसे जा रहा था, फिर ये हुआ, फिर वो हुआ, फिर उसने मेरे को धक्का दिया, मारा पीटा और उसके बाद भाग गया. इसमें काम की चीज क्या है? धक्का दिया, मेरे घर में घुसा, ट्रेसपास हो गया, धक्का दिया, सिंपल इंजरी 323 आईपीसी बन सकता है, ठीक है, और भाग गया 352 आईपीसी में भी बन सकता है. ओके, द इंसिडेंट इटसेल्फ, जो क्राइम हुआ, कॉग्निजेबल ऑफेंस जो बनता है, so that is the important thing when you're going to lodge an FIR. Okay, because all that are the story, and never, second important thing is never attempt to manipulate कि ठीक है ये भी ऐड करा दो, वो भी ऐड करा दो, try to make it big and strong. See, as the judicial officer just shared with you, that courts, mind you, judges are very sharp people. We hear a lot about every stigmata, every segment of our society. But judges are very sharp people. दूध का दूध, पानी का पानी निकल आता है. सिमिलरली आईओ का वो डेली काम होता है जो हमारे डॉक्टर्स का होता है. क्या हम कई बार डोंट वी हैव ए फीलिंग द पेशेंट वॉक्स इन आवर चैम्बर एंड वी नो in one sentence what she is suffering from. Similarly, it is the job of investigating officers. What is truth and what is not truth, they can know in a moment. So never try to manipulate. जो incident है उसको incident की तरह ही बताओ. If you are sure that the incident has occurred, you have witnessed everything and you have got supporting evidence, then that is enough to make the opposite party, the defendant, liable for his acts. So that is second important thing. If you refuse to sign a FIR that you have complaint form, yes, technically, lawfully it becomes an offense, but इतना hard and fast नहीं है. FIR लिखित में आ गया, पुलिस ने लिख लिया. It is still a good piece of evidence in a court of law. This is what is 154 CRPC. You are not supposed to read it. I'm just telling you that there are three important elements of the 154 CRPC. And what are these? That it is a report about commission of a cognizable offense. One. Secondly, it has to be written, whether given in oral form or reduced into writing, or given in written form to the IO and then signed by the informant, and it should be recorded in the daily diary of that police station. ठीक है, वो तो एक legal or enforceable investigating requirement हो गई. But then what is the procedure to lodge an FIR? When you go, the officer has to write it out, whether type it, it's fair enough, and read it out to you, all the details, and give to you a free copy as per 154 CRPC itself, and you are supposed to sign it. So what happens is, when you have given a information to the police, now as I said, it is not Gita truth. The police will, so it is only an information to begin an inquiry by the IO whether there has been a commission of a cognizable offense or not. Okay, so if you learn with time, or the police learns with time upon investigation or preliminary inquiry, that there is more to it, then the police has the liberty to add more sections of law into it, more laws into it. And if the police think that कि नहीं पहले ज़्यादा बताया था but कम है, actually the police has the liberty and the power to decrease those offenses that they have already recorded even in FIR. अब यहाँ पे ठीक है, वो corruption का element doubt किया जाता है, but I am talking about what the laid down law is. That the offenses can increase upon investigation, they can decrease upon investigation. FIR can even be cancelled at the level of the police. I'll come to that in a moment. There are some important case laws, although there are, hundreds, but, very, very basically, in the state of UP versus Mukesh, the apex court held that the FIR is only about intimation about the occurrence of an incident. In the state of Haryana versus Chaudhary Bhajan Lal, it was held that when information disclosing a cognizable offence is laid before the officer in charge of a police station, he has no option but to register the case on the basis of such information. There is a landmark judgment, not very old, of Lalita Kumari, which I'll come to in a moment. FIR on telephone, we have got conflicting judgments. Yes, it could be considered as a FIR, it could not be considered as a FIR as per Damodar versus state of Rajasthan. But where to lodge an FIR? Of course, in the jurisdictional police station, but then it is not mandatory. In case of heinous crimes like, rape or, even any other crime, there is a facility of zero FIR, and which is nothing but the information about information of a cognizable offense, where the police station, the IO will not give you a FIR number, but the FIR would be registered and then transferred to the jurisdictional police station for further investigation. For example, Sushant Singh Rajput, he died in Mumbai and his father lived in Patna. So zero FIR was registered there. Then it was transferred to Mumbai for further investigation. So it is routine for the police. Asharam Bapu case, yes. So EFIR facility is there now in many states. So we can avail that. But yes, if we report falsely that a cognizable offence taken place and upon preliminary inquiry the IO comes to know that there is no cognizable offence, so they can have the liberty to cancel the FIR, or this, in fact, as the judicial officer was talking about, that facility of preliminary inquiry, this is very, very important for doctors. Here we come to the Jacob Matthews judgment, that FIR either cannot be registered, or if can be registered, then doctor will not be arrested unless the report of the preliminary inquiry committee, the judgment says very clearly that maybe doctors in government service or a board of doctors will conclude that yes, there has been no medical negligence and therefore doctor will not be arrested. Or worse se worse, let us say rarest of rare, agar IPC means that it is bailable at the level of police station itself. You don't have to go to the court. You are free to go home after a few minutes after signing certain papers. ऐसा नहीं है कि हैंडकफ करके डॉक्टर साहब को बिठा के रखेंगे जेल में. It is a bailable offence. Okay, worst case worse. So in state of Andhra Pradesh versus Punati Rumalu, the Supreme Court held that refusal to file an FIR is negligence of duty on the part of the police officer. Another important thing is that the timing if there is delay, there is a lot of suspicion by the investigating agency as well as the courts of law that why was there, if it is justifiable. For example, courts have rightly so ruled that in cases of rape and other heinous crimes, it is justified that FIR has been filed late, even after a few days of the incident, because the family has to decide what to do now. It is a big thing. It's not a small offense. So, in the same line, if we have to file a FIR, we should lodge the FIR as promptly as possible. Then only it has much value. The longer we delay, the value of FIR becomes less. So, in state of Punjab versus Gurmeet Singh, the Honorable Apex Court held that in sexual offences, delay in FIR is reasonable because of reasons of family and so many other things. So, it does not decrease the value of or the weightage of the FIR. What is the evidentiary value of FIR? It can, as I said previously, that the statements made in the FIR, see, the statements cannot be changed. That is why we insist that only the minimum possible or only what is important as far as the offense itself is concerned only be told to the IO, so that it can be reduced in writing. The more you tell, the weaker it might become, because the longer story, the longer will be the cross examination in court, and the more are chances that you are liable to fail in your evidence. It's part of my duties to have attended more than 1,000 evidences in courts of law as a forensic person. So the value of FIR is to corroborate or to contradict the whatever is written in the FIR itself. I'll skip this. Purely legal ho jata hai. We cannot have a second FIR if it is already there. The FIR can be quashed only by a high court, not by a lower court, magistrates courts or another court. But what are the outcomes of an FIR? If a offence has been finalized, then a charge sheet would be filed as per law, and it would be then filed in a court of law, and then the court will decide whether the offences stand or not, and the court will frame the charges against the accused persons. The IO has the liberty to file a final report where he could cancel the FIR if there is no evidence to suggest a cognizable offence. Then he could file a untraced report if the accused is not traceable, and if the charge is filed, then the court could order for further investigation also. It is at the liberty of the court. So if the police refuse to file an FIR, you can approach the DCP of the area under 154(3) CRPC to urge them to lodge an FIR, and if he also refuses, you can approach the court under 156(3) CRPC. See, these are so common sections, 154(3) CRPC and 156(3) CRPC. Everybody knows about them. We should also. So what is the difference between a complaint and a FIR? A complaint is actually a court complaint as per law, as defined under section 2D of the 154 CRPC. So it is different from a complaint as we commonly use the word. Complaint is actually a legal word in law parlance, in criminal law. So it only means complaint to the court. And FIR is just information about cognizance of a happening of a cognizable offence. So this is the important. This will be my last part. Lalita Kumari versus Government of UP 2008. It says that registration of FIR is mandatory under 154 CRPC whenever any person approaches to the police about happening of a cognizable offence. Then the IO will conduct a preliminary inquiry under 157 CRPC to see if the cognizable offence that has been reported actually happened or not. And a copy of the FIR will be given to the complainant free of cost, and that the preliminary inquiry, ऐसा नहीं है कि एक महीने तक inquiry चल रही है, but it has to be closed within a period of 1 week. The police officer cannot avoid his duty of registering cognizable offence, and the scope of preliminary inquiry is not to verify the veracity of the offence, but about whether the offence has taken place or not. So IO is not a judge. Okay. IO हैज टू सिंपली, अगर ऑफेंस बनता है तो उसको रजिस्टर करना है. उसका वेटेज कितना है कोर्ट डिसाइड करेगा ना, ये आईओ का काम नहीं है. So, and this judgment specifically mentions that preliminary inquiry has to be conducted in medical negligence. This is from the judgment itself. So, these are some examples that the court has given, that where a preliminary inquiry will be conducted before filing a FIR, and medical negligence cases are one of those. And I will not talk about Jacob Matthews, it has already been talked a lot. And just one line about this, that you should always have a copy of this with you and use it effectively in your favor to prevent yourself from arrest. And this is, as I said, this gives you so much of power and right, I would say, that it is not available to, probably the rest of the country. Okay, so lastly, I would just say that other than this, so you also have some, rights as a arrested person, but then that is a different topic altogether, huge topic. So I'll just skip it. Yes, you have a right to remain silent and whatnot. So many other rights. If in case arrest does happen, that you should know that there are definite laws that give you, solid rights as a person who is arrested. If there are quick questions, I'll be happy to take. Thank you so much for the time.